Hi, I'm attorney Jeremy Huss. Can a person be convicted for a DUI while sleeping in their vehicle? The answer to that question is yes, and may be proven through an analysis of specific facts in each case. Imagine this scenario. You were out for a few drinks after work or on a weekend night with some friends. You have a couple of drinks, but make a decision to drive your vehicle home. And during that drive, you realize you are impaired to the slightest degree. So you make the good decision to pull your vehicle over. You fall asleep in the driver's seat, and before long you hear a knock at your driver's side window. One of two things has likely happened. A concerned citizen has called in, or the police officer saw you in your vehicle while on routine patrol. Regardless of how you and your vehicle came to law enforcement attention, the officer without a doubt will conduct a welfare check on you. And that is the knock you heard at your window while sleeping in the driver's seat. The officer will want to make certain you are okay and is legally justified in his contact because it is a welfare check justified under an exigent circumstance. If an officer detects the odor of alcohol or marijuana or notices lethargic movements with bloodshot eyes, a DUI investigation will certainly follow. Obviously, a person waking up out of a slumber will move slow and lethargically, and will also likely exhibit bloodshot eyes and demonstrate other symptoms that appear consistent with impairment. However, keep in mind that an officer approaching a sleeping person in a vehicle is already on heightened alert and assuming the person is impaired. So the officer is going to approach the contact with that mindset. However, as we all know, just because law enforcement believes something and makes an arrest does not always make the situation truth or fact. Rather, Arizona law is clear that determining whether a person is in actual physical control of a vehicle and therefore committing a DUI is based on the totality of the circumstances present. What the law is looking to distinguish through this totality of the circumstances is whether a person is using the vehicle as a stationary shelter, or does the person have actual physical control? If the person has imminent actual physical control, that vehicle can be placed into motion imminently and place any driver on the same roadway at risk. However, the person is using the vehicle as a stationary shelter, then the person is not exercising actual physical control and does not theoretically pose the same imminent risk. Let's look at some of the totality of the circumstances factors analyzed in determining whether a driver has actual physical control versus using the vehicle as a stationary shelter. Let's think back to our example. You had pulled off the road because you were starting to feel that you were impaired to the slightest degree. The first factor law enforcement is going to be taking note of is whether the vehicle's ignition was on or not. If the ignition is on, the state has a fairly easy argument that this vehicle could imminently be placed into motion and onto a roadway. However, if the vehicle is off, there are more steps a person must take to put that vehicle into motion. This fact is analyzed in conjunction with a second factor, which is where and in what position the driver was found in the vehicle. Most of the time, a person is contacted sleeping in their vehicle while in the driver's seat. Contrast this with a person sleeping in the back seat of the vehicle. This person must take multiple actions to put that vehicle into motion. Another factor in making this determination is where the vehicle was stopped, and was it a voluntary stop by the driver? Sometimes people are sleeping in the driver's seat at a stoplight with the vehicle running. Sometimes people pull off the roadway but leave a portion of the vehicle in the street. Obviously, a person legally parking off the roadway in a legal location is not necessarily exhibiting a lack of perception sign of impairment, like a person sleeping at a stoplight or leaving a portion of the vehicle in the street. Also, a person sleeping at a stoplight did not voluntarily pull off the road as a person who legally parks in an allowed location. Location of the key is also a factor to determine, but not as important of a factor as it once was. The reason for that is that most modern vehicles do not require the key to be placed into the ignition. The key essentially can be any place in the vehicle to start the vehicle's engine. Nevertheless, key location is still a factor utilized in this analysis. Now, these factors just discussed are not an exhaustive list for determining whether a person has actual physical control of a vehicle. However, they are some of the most important factors in the analysis. Arizona prosecutes DUI cases harshly. It is imperative for any person who has been investigated, arrested, or charged for DUI while sleeping in the vehicle to consult with an attorney experienced with these specific issues and DUI investigations. I've been handling DUI cases for over 20 years and have handled numerous actual physical control issues as both a prosecutor and defense attorney. If you have a charge for DUI while sleeping in your vehicle, call Huss Law today for a free consultation.